The second case for oral argument this morning is Chad RUS, appellant, versus the state of South Dakota appellee. For the appellant, we have Mr. Bert Bucher, an attorney from Sioux Falls, and I understand you'll do the first 20 minutes, and then Mr. Stephen Bucher will do the 10-minute rebuttal.
That's correct, Your Honor.
Very well, and for the appellee, state of South Dakota, we have Ms. Rachel Merrose, a Aurora County State's Attorney from Plankton. With that, Mr. Bert Bucher, you may proceed, sir, and you have 20 minutes.
Mr. Chief Justice, may it please the court, counsel. My name is Bert Bucher. I'm here with co-counsel Mr. Steve Bucher to represent the appellant in this matter, Mr. Chad RUS. Chad RUS was arrested on July 25th, 2019 on a felony warrant in Charles Mix County at his place of employment. He was taken to the Charles Mix County Jail and he was booked as a felon. He had to do additional DNA testing that a normal misdemeanor accused would not be taken through. The question before the court here is then, do we continue to consider this a felony, or do we consider this a misdemeanor until the time of conviction and then immediately move it to a felony?
Well, surely the manner in which he was arrested wouldn't in and of itself convert this to a felony grade offense, am I right?
Certainly not just the manner of arrest alone, but when considered with South Dakota Codified Law 23A-4-3, which states in relevant part that no defendant is entitled to a preliminary hearing unless charged with an offense punishable as a felony. In this case, although the state is trying to tell us right now that this case is only a misdemeanor and the defendant is only entitled to certain misdemeanor safeguards at this time, this sort of situation was troubling enough for the court previously in Helling and Anders to notice this defect and say that there's a defect that needs to be cured. Respectfully, that's why we're here today. We're here to give the court an opportunity to cure that defect, to ensure that every accused person in this state receives procedural and statutory due process according to the laws of the land. The lower court's ruling in this case violates the doctrine of in pari materia, meaning that all statutes must be read together. You can't take one and parse, and likewise you must consider every word in a statute. We presume that the legislature does not use superfluous words. They use every word with a meaning. The clearest indicator of legislative intent is the statute's plain language, according to State v. Living Good. 23A4A clearly states that you are not entitled, no defendant is entitled to a preliminary hearing unless they are charged with an offense punishable as a felony. In this case, the defendant was arrested and booked as a felon. At the initial appearance, he wasn't quite sure where it was, and the initial motion was made, let's have a preliminary hearing. Let the defendant know what he was accused of, let him know what the maximum penalty would be so that he can make an intelligent, knowing, and voluntary plea.
I looked for that transcript in the record, and I didn't find it. I found the transcript from the motion hearing, but maybe I overlooked the transcript from the initial appearance. Is that in the record, and did I just miss that?
I don't believe that initial transcript made it into the record.
Is it disputed or undisputed as to how your client was advised? Was he advised that this is a misdemeanor grade offense, class 1 misdemeanor, or was he advised that it is in fact a felony, or a felony is in the offing, and he should be apprised of that too?
I'm not quite sure I understand your question. Could you rephrase for me?
How was he advised at the initial appearance concerning the maximum punishment?
That question was not answered at the initial appearance. That was maybe a cart before the horse scenario where the judge was getting ready to do that, and co-counsel said, wait, we need to have a preliminary hearing. According to the laws. He hasn't been indicted by a grand jury. He hasn't had a preliminary hearing. The statutes squarely require that, and as such, we need to have a hearing on whether or not there is a preliminary hearing. That's the hearing that took place in October.
Okay.
So, in this case, we have a defendant that is concerned about his rights. He's concerned about what rights he will lose. As you know, in this state, if you are a felon, above and beyond the penalties of a fine or incarceration, he also loses his ability to own firearms. He loses his ability to vote in elections, hallmarks of our democracy. For this to start as a misdemeanor and then move into that felony after one or two trials based on whether we're trying the preliminary information or the supplementary information, it seems to shock the conscience. I don't know how a defendant is expected to stand in front of a court and say whether they are guilty or not guilty if they don't know what the final and ultimate penalty will be for those actions, for those accused actions. And so, in this case, we seek the court's clarification of the prior ruling and the consideration of all of these statutes together to really stand on 23A4.3, which provides that a defendant is not entitled to a preliminary hearing unless charged with an offense punishable as a felony.
Does the state,
Go ahead, I'm sorry.
does the state, to protect its record, in this case, have to file the two parts of the information simultaneously?
It would be the appellant's contention that, yes, these should be filed contemporaneously. In this case, the Part 2 information was filed very close in time to what was to be the arraignment at that point, maybe the day before, as late. And in that case, the defense doesn't have adequate time to consider that Part 2 information. It's snuck in the side door right before we begin proceedings.
Well, it doesn't make it right, but when I was a young lawyer in our circuit in the Northeast, if you didn't file them simultaneously, the judges said the right to file the Part 2 was waived.
And in this case, I think since it did come before the quote-unquote arraignment, it would be considered timely. I don't know that timely is enough to hang the hat on here. In this case, the defendant has felt like he's a felon already. He was arrested on a felony warrant. Now to take that away in this intermediary portion between the charging and the trial court, and maybe even through the trial court, he would still be thinking, well, maybe I'm a felon, maybe I'm not. And then once he's convicted of this misdemeanor, this Class 1 misdemeanor, driving under the influence, is it the interpretation of these statutes that he is automatically guilty of the subsequent felony, the underlying felony, because he's got these two DUI convictions in 2008 and in 2011 and 2016? In that case, that Part 2 information, if these cases were in Aurora County, and I believe one was, the state would be able to ask the court to take judicial notice of that conviction or those convictions, or the court could, sua sponte, take notice as it did in State v. Olison some years.
Counsel, help me understand that argument. Wouldn't your client have a right to deny the Part 2 information and request a jury trial or a court trial and put the state to its proof?
He would have that right, but in that case, the record is already settled that these convictions have already occurred. If he already pled guilty to them, which...
Well, they still have to prove that he's the person in that previous conviction. They just can't wave the court file in front and say, see, he's guilty 2 previous times.
That's correct,
You
Your Honor.
don't have to prove a crime occurred. You have to prove he was the person that committed it.
That's correct, Your Honor. A very, very low burden, I think, in the appellant's opinion, that he's not... the whole bite of the apple starts at the beginning of this. The whole bite of the apple needs to start and ensuring that he has the constitutional protections all the way through. There are...
The constitutional protections you're talking about are what?
The right...
Knowing what the statutory maximum penalty is, because there's no constitutional, as I read it anyway, there's no constitutional requirement to test the charge by probable cause. There's not a grand jury clause like the Fifth Amendment to the United States Constitution has, at least that I can see in our Constitution. But nevertheless, as you say, we do have statutes that seem to suggest you have to have a preliminary hearing, and then, of course, we've got an exception that says you don't have to have one within 15 or 45 days, depending upon custodial status, if the case is indicted first. So we've got an allowance for that. But it seems to me like this is more a question of statutory compliance in the first instance with the requirement to give someone a preliminary hearing.
Absolutely, Your Honor. As you stated, this is about finding out what the defendant is charged with. It's also about finding out what the defendant's maximum penalty is. And maybe most importantly, it's about the right to confront his accuser. In this case, the accuser is a deputy sheriff in the county. And
so that would be a Sixth Amendment argument. I didn't see that raised anywhere.
I believe in our brief to the court on page...
In any event, this seems like a trial right as well, right? You're at trial, you need to confront somebody, and they're deemed to be, necessary, or their testimony is testimonial under Crawford.
Certainly.
If we accept your argument, we have to overrule Helling, which sort of seems to suggest that these should be treated more like misdemeanors.
I'm sorry?
We have to overrule our Helling decision, which suggests that these cases should be treated more like misdemeanors, and specifically the language in Helling that says, the recidivist enhancement for DWI convictions is really more akin to a sentencing enhancement than a new offense. Do we have to overrule that?
I believe either an overruling or a distinguishment is in order in this case. In Helling, the defendant did in fact waive preliminary hearing. In this case, no such waiver has occurred. Additionally, South Dakota 23A43 has been modified in years past. At that time, it seemed to suggest that both Class 1 misdemeanants and accused felons would be entitled to a preliminary hearing. Now the statute has been modified, and it reads, no defendant is entitled to preliminary hearing unless charged with an offense.
I'm smiling now at your argument, which is a fine argument, but I'm smiling because the legislative history has a little bit of it's a little uneven.
Yes, sir.
It starts as a statute, continues as a statute. Then in the 2000s, actually 1990, and then in 2000, the court modifies the statute. And then we have this reenactment as part of Senate Bill 70 in 2013. So as we sit here today, I agree with you. It looks like a statute, although maybe along the way it wasn't so clear.
And the thought that this is an offense that is punishable as a felony, it does relate back to that Sixth Amendment argument we made on page 6 of our brief. Both the Sixth Amendment of the United States Constitution and Article 6, Section 7 of the South Dakota Constitution guarantee every defendant the right to be informed of the nature and accusation against him. And through the 14th Amendment, it guarantees that the liberties and due process will be guaranteed for every defendant. In this case, we would argue that because he faces a felony punishment, he should have the rights that a felony defendant has during the trial court proceedings.
So is that why this is ripe? I mean, is there a ripeness question? The case is decided by the Circuit Court on September 25th. Part 2 is about a month later on October 22nd. At the time, the Circuit Court denied the motion for a preliminary hearing or to limit the punishment to a Class 1 misdemeanor. There was no Part 2.
At that time, you're correct.
So maybe there could be an argument that the Circuit Court could be affirmed just on that basis alone. But as the record indicates and the briefs indicate, that the state sort of said all along, hey, we're going to do this. If there may be a ripeness issue, I'm going to ask the state about that. But you mentioned this punishable text from 23A43. Is that how you navigate maybe around that? Because whether it was charged that way at the moment, it is nevertheless ultimately punishable as a felony?
Precisely, Your Honor. It makes no difference, and the legislature, after this had been through the ringer and modified and adjusted many times, decided that offense charged is punishable as a felony. That's the way that this needs to read to ensure proper safeguards for defendants in this state.
Have you completed your presentation, or are you just pausing?
At this time, I would like to reserve the rest of my time for rebuttal from my co-counsel, if there are no other questions.
You'll get 10 minutes for rebuttal. Okay?
Thank you, Your Honor.
All right.
Thank you, Your Honors.
No one is ever chastised for quitting early. I failed to note the presence of Mr. Steele. They have his computer screens up here. I didn't see you, but welcome.
Thank you, Your Honor.
Okay. Then we will have Ms. Mary Rose present for the state, and you have 20 minutes.
Thank you. May it please the court and counsel, my name is Rachel Myros, and I'm the Aurora County State's Attorney. We are here today on the issue of whether a defendant charged with a misdemeanor should be afforded the rights of a person charged with a felony. I respectfully request that you uphold the lower court's ruling and hold that a defendant charged with a DUI is not entitled to a preliminary hearing. The key to this case is the application of pre-trial criminal procedure to the facts. The defendant was charged by complaint and information with 3 misdemeanor offenses, one of which was a DUI. Defense counsel then moved for a preliminary hearing on the DUI charge. Following the court's ruling on that motion, I filed a supplemental information against the defendant containing 2 prior DUI convictions. He was then arraigned on both the primary and supplemental informations.
Were those 2 informations filed simultaneously?
They weren't filed simultaneously. The complaint and the primary information were filed at the same time, but the supplemental wasn't filed until the day before arraignment.
So you don't consider you waived the right on the Part 2 by not filing it at the same time as Part 1, telling him what he is facing as a punishable offense?
I've never heard that rule before.
Well, in the Fifth Circuit where I came from, it was mandatory. In fact, I saw at least a couple cases tossed on the felony side because they were not filed simultaneously.
My understanding is that it just has to be filed before arraignment so that he can be properly informed of his rights at arraignment.
Okay.
Ms. Myros, was my chronology right? The Circuit Court, Judge Smith denied this on the 25th of September, and then the Part 2 looks as though it was filed, I might be a day or 2 off, but it looks like it was October 22nd.
That sounds right.
So at the time the Circuit Court made the decision, there was no Part 2.
That's correct.
I read your briefs correctly. You're not really saying, yeah, this is not a ripe issue because the because the Circuit Court didn't have Part 2. You're not making that argument for Part.
Well, it's correct that at the time he made that motion, the supplemental wasn't on file, but we had told him that we had planned on filing the supplemental, so they knew about it. In fact, shortly after the arrest was made and Mr. Bucher was hired, we informed him that we planned on filing the supplemental.
And so you're not here saying, well, you tell me if you are or not. The way I read your arguments, it doesn't seem to me that you're saying, we want you to affirm the trial court because this is just not justiciable. It's not ripe yet. There was no Part 2 at that moment in time, and so the Circuit Court's decision can only be considered correct. I don't hear you making that argument.
My argument is more based on the fact that at the point when he asked for a preliminary hearing, he was only facing the charges in the complaint. Because a preliminary hearing has to come between the filing of the complaint and the information. So if he had a preliminary hearing, it would only be based on those charges in the complaint, which are misdemeanors. I wouldn't present evidence of his prior DUIs because those aren't elements of the offense of DUI. Those would only come up later as sentence enhancers. So a magistrate judge could only bind over charges he or she thought there was probable cause to proceed on, which would be misdemeanor offenses. Or
at the time you filed Part 2 of the information, would he then be entitled to a preliminary hearing since he's now facing a felony?
No, there is no right to a preliminary hearing on a supplemental information, and that answer was given by the court in State versus Stephenson. Under very similar facts, and the court ruled that there's no preliminary hearing on the supplemental.
Well, of course, at the time Stephenson was decided, you were entitled to a preliminary hearing on a Class 1 misdemeanor. So the issue we're facing today would never have come up.
Well, true. In Stephenson, he did waive his right to a hearing because he was entitled to that right, but then he later claimed he wasn't properly bound over because he didn't have a preliminary hearing on the Part 2 information. So the court did rule on that motion or on that issue by saying you don't get a preliminary hearing on a supplemental. And the reason for that is because the supplemental information doesn't charge a new distinct offense. It's only used at the last stage where the judge gives the appropriate punishment.
But does that really, I know our cases say that, and so I can't be too critical of you for saying that, and I wouldn't be anyway, but does that really square with our text our recidivist DWI statutes, including DWI 3rd, for instance, 32-23-4, the first line of which reads, if conviction for a violation of the DWI statute, 32-23-1, is for a third offense, the person is guilty of a Class 6 felony.
Mm-hmm.
It seems to me that one way you could read that text would be to suggest, or would be to interpret it as elevating the grade of the offense from a Class 1 misdemeanor to a Class 6 felony.
That's correct, but this DUI only gets to be a third offense DUI after he's charged with the DUI in a complaint and a supplemental information is filed against him. He has to be found guilty of that underlying DUI, and then he has to be identified as the same person that committed the prior DUIs in the supplemental information. And then after that, he's considered a third offense DUI offender.
So along that continuum of time, when is he charged with a felony?
I don't think he could be properly considered charged with a felony until after that second trial on the supplemental information.
Until after. If that's the case, then the provision for a preliminary hearing in the statute, which is at the heart of this dispute, 23A43, would never apply, ever.
No, I don't think it would ever apply. Not to any DUI offense, or even simple assaults have the same elevation or violations of a protection order.
So if it seems to me like part of your argument contemplates that somebody's not charged with a felony until they're found guilty of a felony. But charged with a felony seems much different than being adjudicated guilty of a felony.
I would agree that they're different, but I still think we need to keep in mind that there's two phases to this process. There's the underlying guilt on the primary DUI, and then you get to the supplemental part where he becomes a felony offender. And
well, that may be his status, but is he not charged with a felony at some point prior to crossing that threshold to that status?
no, I think if you want to argue he's been filed or charged with a
I
felony.
don't want to argue at all. I'm just joking. I'm just trying to lighten it up.
Well, to steal a phrase from Mr. Bucher, that would be putting the cart in front of the horse, because you would kind of be assuming his guilt on the underlying DUI when that has to be established first before you get to the supplemental information. I just don't think there's any way the defendant could be said to be facing felony punishment at the point where a preliminary hearing would be appropriate, since that has to be held before the filing of the information. Mr. Bucher bases a lot of his argument on the footnote in the Anders decision, and I would argue that Anders is distinguishable from our case. The issue facing the court today is not the same issue that Anders was facing. Their issue there was whether a felony DUI can be used to enhance a subsequent felony under the habitual offender statute. So the court there wasn't addressing what kind of rights a defendant should have on the underlying primary offense. They weren't addressing peremptory challenges or the right to a preliminary hearing. They were addressing how to handle a DUI that's already been elevated. So I don't think the footnote in Anders should be given any weight when this court makes their decision. One point Mr. Bucher made that I do agree with, however, is that the statutes have to be read within the context of the statutory scheme as a whole. I don't think it would be appropriate to take out the one word punishable out of context and base a decision just on that word. I think it was the clear intent of the legislature that misdemeanors should not be given the right to a preliminary hearing because they took out that right in 2013 when the statutes were amended. And then the line following that sentence, an offense punishable as a felony, the next sentence reads, if the defendant waives the preliminary hearing, the committing magistrate shall forthwith hold the defendant to answer in circuit court if the offense charged is a felony. And so there the language that they used is charged. And then the companion statute, 23A63, states that no information may be filed against any person for any felony until that person has had a preliminary hearing. So reading all of these statutes together, the one sentence that uses the language charged as a felony, along with the fact that Class 1 misdemeanors were taken out of that statute, clearly shows that the legislature did not want Class 1 misdemeanors to have a preliminary hearing. And I think it's also worth noting that Anders was decided in 2009, and the statute was amended in 2013. So not only did the legislature not take heed of the footnote in Anders and amend the statute accordingly, but instead they amended to take away rights. And at that time in 2013 when it was amended, that would have been a good time if they wanted to make an exception for certain misdemeanors, such as DUIs or assaults or other charges facing potential elevation. They could have made an exception at that time. But I think it's telling that they chose not to. We have clear precedent from this court on this issue that aids us in answering this issue, and that is the Helling case. And in that case, the defendant asked for extra peremptory challenges on his underlying trial for DUI. And there the court held that the supplemental information containing prior DUI offenses is just a punish enhancement statute. It's not a separate distinct offense. And so the court there held that in the underlying trial, you're going to be treated as a misdemeanor. And he wasn't entitled to all the panoply of a felony trial. So in essence, what the court was saying was that you'll be treated as a misdemeanor throughout the trial on that primary offense. And I think Helling is still good law, and I think it should remain good law.
Statutes contemplate that the Part 2 can be not a Part 2, if I'm thinking about it correctly. They contemplate that the original charge could contain a separate component that alleged the prior convictions. I think I'm right on that. If that were the case, then does that change your argument? In other words, let's say that the complaint charges the principal offense, but also alleges that in the same document that this defendant has 2 prior convictions within 10 years for DWI. Mm-hmm. So it's there. It is, as the Chief Justice indicates, simultaneous. But not only that, it's in the same charging document. Is the defendant at that time then charged with a felony? I know that didn't happen here, but in that instance, is the defendant charged with a felony?
I know it didn't happen here, and I'm not sure that's a procedure that could ever happen. Since under 3223-4 and 4 through 8, those prior charges have to be contained within a separate information. They can't be contained with the charging documents, and the reason for that is prejudice. We don't want the trial on the primary offense to take into consideration his prior bad acts because we don't want to convict him on his prior history. We want to convict him on whether he met the elements of the offense of
Well,
DUI.
let's say that you could eliminate that by the trial court just simply not conducting that portion of the trial at that moment. Is the person charged with a felony or grade offense if they're alleged at the same time? That prior conviction, that is.
I still don't think so, Your Honor, just because if those prior DUIs were contained within a charging document, those wouldn't be separate offenses. Those would still only be sentence enhancers.
Okay. I understand your answer. Thank you.
If there are no more questions, I might finish early.
Okay, you too will not be chastised. Thank you. Okay, Mr. Stephen Bucher, you have 10 minutes to rebuttal, sir.
May it please the court, counsel. I am Steve Bucher, and I'm here representing Chad RUS, the defendant. We've heard the opening arguments from both my co-counsel and the esteemed attorney for the state. I'm trying to confine mine to statements that could be considered rebuttal. I think everyone in this room, this state, and this nation knows that criminal defendants are constitutionally guaranteed the right to due process of law. We're here today to decide how much process Chad RUS is due. Respecting rights of those of us criminally charged, I would argue, is one of the most important, if not the most important, obligations of our system of law. If the court system doesn't work for Chad RUS, it doesn't work. That being said, affording those of us charged with crimes their statutory and constitutionally protected rights is often messy, inconvenient, and a lot of times inefficient. Still, they are important. It seems to me...
Is this case about the preliminary hearing, or is it about correctly advising your client what the maximum punishment is, or both?
It's both. It is knowing what you're facing before you're called upon to make decisions, not only with pleas, but are you going to hire an attorney? Are you going to defend? Are you going to plead guilty?
But on the case we have in front of us right now, there's really no prejudice that I've seen, or maybe that has been suggested in the submissions, that your client was somehow prejudiced or in a real way is laboring under this imprecision right now. The way maybe I'm wrong. Well, the way I read the submissions was, hey, he should have a preliminary hearing. This is a right that he should have. And if that's the case, do you agree that that's just a statutory right? There's not a constitutional right for him to have a preliminary hearing, at least in this state.
Well, I think the right to due process involves interpreting and applying the statutes. That's what due process is about. So it's a constitutionally guaranteed right. You can't ignore statutes, okay? And I think my co-counsel talked about statutory due process versus, I think it was substantive, or criminal rules should be clear, comprehensive, logical. If the court accepts the state's position, that will not be the result. The circuit court made mention from the bench in his ruling that maybe at a later point in time in the proceedings, a preliminary hearing right would attach. I was rereading the amicus brief yesterday, and it struck me, the quote on page 8 from Ronald Ryan Smith's, that the purpose of the right to due process must be granted at a time when the deprivation can still be prevented. I submit that the time is now, and this court is the place. Requiring my client to face trial without a preliminary hearing makes him an unwilling participant in a game of legal three-card Monte. That is to say, he'll need to be following the red card through the felony arrest, okay? Then the black card, since it's treated as a misdemeanor in pretrial and trial, then again it turns into a different color card when it's time for punishment. What color card is it then? Games of chance have a place. I submit that The place is not in the criminal court in South Dakota. I ask this court to overturn the circuit court's decision and correct this and allow my client, Chad Russ, the right to a preliminary hearing.
Thank you, Mr. Bucher. The court, we also broadcast these oral arguments over the internet, and this has gotten done a little early. Usually we take a 10-minute break, but the next one is not scheduled until 11 o'clock. And so in order to keep on our normal schedule, we'll be in recess until 11 o'clock, and then we'll hear the third case. We are in recess.